This conference will now be recorded.
Can you turn your mic? Turn your mic. Turn it on. Heather, just hit the button on that one next to you.
Good evening, ladies and gentlemen, and welcome to the Board of Adjustment meeting, July the 24th, 2024. It's good to see you all. There are agendas on the podium if you would like one. If not, we will move right into discussion. I will call the meeting to order. Madam Clerk, do we have a quorum? Moving on, I will entertain a motion to approve the minutes from August 1st, 2022.
Motion to approve the minutes.
Second.
Heather Granger motions. Sean Barnhill seconds. All in favor, please signify by raising your hand. Thank you. Unanimous approval of the minutes. At this point, I would like to amend the agenda before we approve it. And we're going to go into closed session by General Statute 143-318.11, subsection A3, client attorney privilege. So if you will bear with us, we're going to step into the conference room and we'll be back shortly.
Madam Chairperson,
Yes,
we could
sir.
have a motion to that effect.
We can. May I have a motion, please, to move us into executive closed session?
I make a motion
Heather Granger?
to move us into closed session.
Thank you. All in favor? Any objection? We'll do that. Thank you very much.
She's the woman with the alternate. He's here, I don't know. Yeah, no, there's not. You know, I tried to make the best.
This conference will now be
This hearing will
recorded.
be continued to a date and time certain within 30 days of tonight, at which time the Board of Adjustment will review and adopt my proposed order or adopt a modified version of my proposed order. And additionally, this hearing, the Board of Adjustment is not required to render a decision tonight. A decision has to be rendered within 30 days. So another option is that the board may wish to continue this hearing to a date and time certain, less than 30 days from now, at which time they would then reconvene, deliberate, and make a decision. Thank you.
Thank you. Moving forward, I believe the first one to speak was Mr. Rush.
Thank you, Chair Fowler. Just one procedural question. Do I need to be sworn in?
Yes, we do
Initially
need to
for-
swear folks in. If you intend to speak as a witness or as an appellate, please come forward and let our clerk swear you in. And then we have three folks who have asked to speak from the audience: Annette Myers, Michael King, and Dot Marsky. If you would all come forward, we'll swear you all in at one time.
Standard. Okay. All right.
If you all can raise your right hand. Do you affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk.
Thank you, Chair Fowler, members of the Board of Adjustment. I think it's probably no surprise to anyone in the room that the property in question is the former Wells Fargo building, literally located across Highway 24 from where we're seated here tonight. It is the former Wells Fargo bank building. It's been vacant for probably the last couple of years or so. In April, we started to receive inquiries from a potential tenant of that building, for that building, and inquiring about the possibility of locating a tobacco and vape shop at that location. As is often the case with any applicant for a zoning permit in the town of Cape Carteret or in just about any town, there were a lot of informal conversations. People explore what they can do, what they can't do, those kind of things. Our town planner, who works directly for me and who I provide direction and guidance to, initially informed the applicant that this use would fit under the retail sales classification. That was in late April. We did not actually receive an application from the applicant until sometime in May. We continued to have a lot of internal conversations about this issue during that time. Ultimately, the permit application was submitted by the prospective tenant, and ultimately that permit application was denied. And during that time, from the conversations in April until the final decision was rendered by me as the town manager, as the UDO administrator, considered lots of additional conversations with our police chief, with our town planner, additional review of the UDO. You have excerpts available to you tonight. And ultimately came to the conclusion that it was not, in my opinion, it is not a permitted use in the B20 zoning district as outlined in our UDO. And essentially, the Unified Development Ordinance is essentially the guidebook or the playbook for myself, our town planner, our board of commissioners in governing the town. So essentially, we are following the guidebook, the playbook, and I ultimately made that determination. That determination was communicated to the applicant and then ultimately to the owner of the building, SB 103 LLC, who's here tonight. I'm sure you'll hear from shortly. Ultimately decided to appeal that determination. So there's an excerpt in your packet from the UDO that basically talks about, provides the instructions for the staff to interpret the UDO and how to make these types of decisions. And that's included at the back of your packet. It's a one paragraph that essentially says when you receive an application, obviously look for an exact match in the table of permitted and special uses. If there's not an exact match, make the best judgment that you can based on the uses that are listed there. And if you're not able to do that, there are two options available. The applicant can request a text amendment, and that goes through the legislative process with the planning board, and ultimately the board of commissioners is charged with adopting any new ordinances or amendments. Or the second option is to appeal the UDO administrator's decision, which is exactly what's happening tonight. And essentially, the actions that I took in rendering the decision and what is happening tonight is following that playbook perfectly. Things are playing out as intended in that Unified Development Ordinance. You all ultimately will render your decision here perhaps tonight or within the next 30 days. There are several reasons that I outlined in the written materials, and I won't go through everything in here for you. But in my judgment, in looking at the table of permitted and special uses, we certainly allow general retail sales. And there are lots of other examples in the community of general retail sales establishments. After considering this in more detail and receiving input from others, I basically looked at it and said, you know, this is a specialty shop. This is by no means general. It is specializing in these particular products. And we've gone to great length in our UDO to be very specific about other types of specialty retail operations. And you've got the whole list in your packet. You've got the whole table of permitted and special uses. But, you know, one of the things that we particularly note is alcoholic beverage stores. And so they're a permitted use in the B20 zoning district. There's several other things. There's bakeries. There's all kinds of different types of retail uses that are included. And so in looking at the alcoholic beverage stores, for example, obviously the leaders of this community that were elected by the people, and in the case of the planning board appointed by the elected leaders, at some point in the past made judgments about what they thought was appropriate to be located in this town, how and where. And I respect that. That's the democratic process. That's the way local government works. The leaders of the community make the legislative decisions. They codify them in the UDO. They went through very deliberative processes long before my arrival with the town, and they determined that these uses are permitted, or in some cases, these uses are permitted as a special use. They decided what zoning districts and so forth. So when I went through the entire table of permitted and special uses, I looked at the specificity that they included for lots of other uses and said to myself, this is really something that's more impactful than a general retail sales establishment. This is the kind of thing that deserves deliberation by the appointed and elected leaders of the town, and therefore ultimately led to the decision to advise the applicant to pursue a text amendment through the planning board, through the board of commissioners. As I'm sure you all know, there are very specific steps in that process, public hearings and so forth. And that was the reason for that guidance, because I respect the fact that the leaders of this community make those decisions. And in fact, they did many, many years over the last several years to come up with the UDO. When you look at the particular application for a tobacco and vape shop, that is very specific. That is more impactful than, say, your typical grocery store or retail convenience store, something like that. They're age-restricted products. There are products that have more significant impacts on the members of our community than lots of other retail establishments. And really, that's the whole purpose of zoning. The whole purpose of zoning is for the leaders of the community to assess, to determine and assess the impacts of different types of uses, and then make those value judgments on behalf of the people that live in this community. So in looking at that, that factored very strongly into my decision. I had testimony from people on my staff and from others that these are going to be more impactful. And again, that's the point of zoning, to mitigate, to manage those impacts, decide where they should go, and so forth. So that was a big factor in the decision as well. And then finally, if you look at the UDO, section 14.8.22, as I mentioned a little bit earlier, it includes language that says the list of permitted and special uses is, quote, specific. That word is included in there, that it is a specific listing of the permitted and special uses. It also says that the UDO administrator, which is ultimately me as the town manager, may determine the most similar use if it's not specifically listed. This was not specifically listed. Debated myself internally, debated with staff about whether or not the general retail sales classification worked, but ultimately was not able to come to the conclusion in my mind that it was similar enough for the reasons that I just outlined for you. And then finally, the language is very clear in our playbook. It's right here, that the applicant may request an amendment to this document, the playbook, or may appeal it to the Board of Adjustment. And in this case, to the five of you. I'm happy to answer any questions that you have about the UDO, about the way that we operate here at the town of Cape Carteret, about the rationale for the decision. But that's a high-level synopsis of what happened. And again, I thank you for your consideration.
Thank you, Frank. Are there any questions for Town Manager Rush?
No.
Seeing none. Next in line, Mr. Arnett. You're going to cross-examine him?
The applicant would like to cross-examine Mr. Rush, if I may.
Sure.
Would you like me to step to the podium?
Please.
Okay, on the ledge a little bit. Good evening, members of the board, Chair Fowler. My name is Elliot Fuss. I'm an attorney representing the applicant in this matter. So, Mr. Rush, you had created a packet of materials that was distributed to the board called Supporting Information for July 24 hearing, right?
Correct.
Okay. And you happen to have a copy of that available to you?
I do. I have the packet in front of me.
Okay.
It's on our website as well.
Super. I'd like to refer to it. So if you can follow along, maybe that can avoid me having to walk over there and show you the memo. But do you have the document right there in front of you now?
I do. Which page are you on?
Okay, if you could look at page 1 and
Page 1 of the memorandum or one of the
yes,
exhibits?
page 1 of the memorandum.
Okay.
Paragraph 3,
Okay.
and I guess it's the last sentence in that paragraph. You said that following internal discussions, the town planner initially informally notified a representative of the applicant via email on on April 26, 2024, that the town would consider the proposed use as permitted under the sales retail classification. Is that correct?
Yeah, that's correct.
If I may, I'd like to.
But as I mentioned in my opening comments, those were that communication was a result of typical informal communications that happen all the time between an applicant and the town staff. But yes, you're correct.
Super. If I may, I'd like to show you what I marked as Exhibit 2. Is it okay for me to distribute copies of our exhibits to the board? Hand it down?
Yes, we would prefer that. Thank you.
Okay.
I believe this is included in the packet already, but by all means, please distribute.
Okay. Looking at Exhibit 2, does that reflect an email that the town planner, Ms. Shambaugh, sent to the applicant's representative?
Yes, it does.
And you were copied on that?
Yes, sir.
And the town planner in April said, quote, "The location is zone B20 and tobacco shops are permitted in that zone as retail sales." Isn't that correct?
That's correct.
And that email went out after you had some discussions with the planner about this proposed use, right?
That's correct. We had numerous discussions in April.
All right. Now, retail sales, as that term is used there, is that the same as what's listed as sales, comma, retail in the town's, in the UDO table of uses?
Yes, sir.
All right. Now, sales retail is permitted as of right in a B20 zone, right?
That is correct.
And the property that is the subject of this matter is in B20, right?
That's correct.
Okay. You would agree that the proposed use here is a form of retail sales, isn't it?
I would consider it a specialty retail shop, yes.
Would a specialty retail shop be a form of retail sales?
I believe it would be a form of retail sales, but I believe that it is much more specific than the general retail sales category.
And the UDO does not include a definition of sales, comma, retail, right?
I don't believe so.
And for the benefit of anyone listening, when I say the UDO, I mean the town's development ordinance. Do you understand that? That's what I mean?
Absolutely.
Okay. Now, since the time that the applicant was advised that tobacco shops are permitted in that zone, you've rethought your position on that issue?
Yes.
If I can direct you back to your memo, we can look at page 2, please. So towards the bottom of page 2, you note that there are some specialty forms of retail sales that have their own specific use listed in the UDO, right?
Yes.
Now, the town, in drafting its UDO, made a decision to treat some specific retail sales uses different from general retail sales, right?
Yes,
So, say an alcoholic beverage store, that's a form of retail sales too, right?
yes.
And the town council, by adopting the UDO, made a decision to have that be separated out into a separate category than other retail sales, correct?
Yeah, along with many other types of retail sales, yes.
But the town council has not created any different category for tobacco shops or vape shops, right?
They have not.
But is it your contention that it's appropriate not to treat the proposed use here as sales retail, even though that the UDO does not single out tobacco or vape shops from any other retail sales use?
Yeah, as I mentioned in my comments, I considered it to be a specialty retail establishment with more and different impacts than many of the other retail establishments that are listed in the table of permitted and special uses, and felt like it deserved consideration through the legislative process with our planning board and board of commissioners.
Going back to the memo to the top of page 3, please. You note there that tobacco and vape shops sell age-restricted products, right?
Yes.
In other words, to buy those products, you need to be 21 or whatever the age is. Is that what that means?
Yeah, I basically looked at it as I sort of made the internal comparison with an alcoholic beverage store. You know, those are age-restricted products. They have different impacts than, say, for example, a T-shirt shop or any other general retail use.
Okay.
And the Board of Commissioners at some point in the past went through the deliberative process to specifically identify that. So I tried to draw the comparison as the playbook, the UDO identifies, consider the similar type uses in there.
Okay. And so is an alcoholic beverage store similar to a tobacco and vape shop in that respect?
I would say that the impacts on the community are probably similar. The potential impacts are similar.
Of the specialty retail sales uses that are listed in the UDO, would you say that alcoholic beverage store is the most similar to a tobacco or vape shop?
Probably so, of the ones that we've broken out.
And you mentioned that alcoholic beverage stores are allowed as of right in a B20, right?
That they are allowed in B20, but they're allowed because this community's leaders went through a deliberative legislative process to arrive at that decision.
And in fact, there is an ABC store that's located in the same shopping center as the subject site here, right?
Correct.
Looking at the second bullet point on page 3, you mentioned that some other people expressed concerns to you that the land use impacts of the proposed use here are likely greater than a general retail use. Is that correct?
Yes.
All right. And specifically, what land use impacts are you talking about?
Yeah. So, initially when the informal internal discussions were going on, I will admit to you and to others that I don't think I had a full understanding of exactly what a tobacco and vape shop was. Over the course of the next several weeks, had lots of conversations with our police chief, with our town planner, and learned more about these things. And that affected my decision to ultimately deny the permit. And so when you look at a retail establishment like that, you have products that are more concerning in the community, probably more significant potential for health impacts, for societal impacts in the community. and in much the same way that perhaps alcohol would be as well. And so again, I basically came to the conclusion, you know what, this is something that the community's leaders really ought to take some time and decide whether this is appropriate or not, in the same way that they considered an alcoholic beverage store. And that's why you have zoning. You're trying to manage and mitigate the impacts of different land uses and trying to locate them in appropriate locations relative to the rest of the community.
Now, also on page 3, the third bullet point there, you reference a section 14.8.22 in the UDO, is that right?
That's correct. And there's an excerpt, there's a copy of that in the packet.
Right. In your memo, you attached as Exhibit J a copy of that UDO provision. Is that correct?
Correct.
Can we take a look at that?
Sure.
Okay, so the title of that provision is Determining Status of Unlisted Uses, right?
Yes, sir.
And this provision provides guidance on how to handle a situation where a use is not covered in the UDO, right?
Correct.
Like if tomorrow a brilliant inventor invented a time travel portal and wanted to put one in Cape Carteret. I mean, you don't have a listed use for that, right?
Sure.
So, I mean, if it didn't plainly fall under some existing use, you'd have to consult this provision to determine, well, where could we put a time travel portal? Nobody's thought of that before, right?
Sure.
And you have agreed that a tobacco or vape shop is a form of retail sales, correct?
I consider it to be a specialty retail shop, yes.
Yes, which would be a type of retail sales.
Understood.
And retail sales, or sales comma retail, is a listed use in the UDO, correct?
General retail sales is a listed use.
Yeah, so retail sales is not an unlisted use, is it?
It is listed in the table of permitted and special uses.
It is, in fact, one of the dozens of specific uses listed in the table of uses, right?
Probably more than 100.
Now, I mean, with respect to all the uses that are in the table of uses, virtually every use could get more specific if you wanted to. Would you agree?
Yeah, so ultimately, you have to have competent individuals working for your municipal government to ultimately make judgments, right? But my role is to make judgments based on the policy guidance provided by the elected leaders of the town. And so I made the judgment that I made, recognizing that perhaps they would request a text amendment and perhaps the planning board and the board of commissioners would clarify the table of permitted and special uses and allow it. So my decision was based on going through a procedure for the elected leaders of the town ultimately to make a judgment about whether or not that's acceptable in that zoning district. Because it is more specialized than a grocery store or a convenience store, those types of things. So that was, right or wrong, that was the rationale that I employed in making the judgment on behalf of the town.
Would you contend that anytime you think it's appropriate, you can say that only some uses that fall under a particular listed use are actually permitted and that others aren't?
Well, I've been working in local government for about 31 years and served in the top position for about 24 of those years, and try very hard to work cooperatively with our landowners and with our applicants to achieve their goals and make their dreams a reality. So I take that responsibility very seriously, but I also have a responsibility to implement the policy directives provided by the elected leaders of the community. And I ultimately made the judgment that they have not adequately addressed this particular specialty use, and therefore suggested that the applicant pursue a text amendment through that legislative process. And I don't know how that process will ultimately turn out, but that's the guidance provided in that section of the UDO that we're looking at right now.
If we were to take another example, are car washes a permitted use in some zone in this town?
Yeah, car washes are permitted in the B30 zone, if I recall correctly.
Okay. I mean, do you think you would have the power to, say, deny a machine car wash because it's different than a hand car wash? Or is anybody who's a car wash get permitted under car wash?
Yeah, I mean, I think it's really going to be very dependent on what the proposal is, right? So, like, I'd have to look at the specific application. I'd have to see exactly what the person's proposing, look at what the specific use is. Quite frankly, there are some that are easier to make a judgment on than others, right? And so ultimately, I made the best judgment that I could on behalf of the community. I hope I make good judgments. I hope they're all right, but that's the judgment that I made. So,
Do you have concerns from a land use perspective about allowing the sale of age-restricted products in this particular area of town?
as long as they are legal products and the elected leaders have allowed for in our UDO that particular use is allowed, I'm fine with that being located wherever it's allowed in our UDO.
I mean, is the basis for treating a tobacco shop different from other retail sales, that tobacco shops are age restricted or have some health concern associated with them?
Yeah, I mean, that absolutely factored into the decision. So I considered the totality of all the conversations I had, all the points that I made in the memo and that I explained in my opening remarks, and ultimately made the judgment that it's just a little more different than a general retail sales use. And again, was just directing it through the process that's outlined in our UDO and adhering to the policy document that was adopted by the leaders of the town.
Do you think that the site in question here would be a bad location to sell a product like tobacco?
Yeah, so again, I don't think it matters what Frank Rush's opinion is on a personal level. I think what matters is what do the leaders of this community want and what have they developed as their policy in our Unified Development Ordinance. And so I have responsibility to do my job correctly. I try to do it correctly and best I can. And ultimately, that's the judgment that I made. So.
And I'm not asking you to give your personal opinions, but I think you've testified that you're a professional with substantial experience. Sure. In managing municipal issues. And as a professional, I'm just asking whether you think that the location we're talking about here is an inappropriate location for selling age-restricted products like tobacco.
Yeah, so in my interpretation, our UDO does not allow this type of use at that location. And that's what I need to follow because that's the policy guidance provided by the elected leaders of the town.
So are you saying by that
So I want every business in my community to prosper. I want every resident, every property owner in this town to do exceedingly well, to prosper, to be happy, to enjoy their lives, to build good relationships with each other. But I have a responsibility to enforce the provisions that are in the UDO that were adopted by the elected leaders. No one voted for Frank Rush. They voted for the various elected leaders since 1957 for this town, 1959 for this town. So I'm simply just trying to administer the UDO and do my job correctly.
Okay, but it's your contention under the UDO, you as town manager do have some discretion, if you feel it's justified, to treat this particular use differently from any other retail sales use.
Yeah, well, I'm tasked with using judgment and making interpretations, right? And someone has to fill that role. And in this particular town, that's my role. I welcome that role. I try to do the best I can. And someone's ultimately got to make the judgment.
And can you clarify whether, as a professional, you think that that location is not appropriate for selling an age-restricted product like tobacco?
So again, what I said is that the leaders of this town have not clarified whether that's an appropriate location. And so my guidance to the applicant was simply to go through that process, to request a text amendment, and for the leaders of the town to make that judgment. And if they determine that's an appropriate location, we'll absolutely write the permit for that.
Okay. So you have no opinion, is that correct?
I don't have any strong feelings about tobacco and vape shops, or really most of the uses, all of the uses in our UDO. Again, I'm trying to build a vibrant community where people can succeed. So I'm trying to be helpful, trying to build a good community where people enjoy their lives. So I'm happy for something productive to go in that building.
From a land use perspective, do you think that a store that sells tobacco products, such as a tobacco store, is different in terms of its impacts from a store that sells tobacco products and other products?
Can you clarify that question a little bit for me?
Sure. Are you familiar with a shopping center?
Across the street?
Yeah.
Sure.
Okay. So you know there's a Lowe's in there, right?
Sure.
Okay. Lowe's sells alcohol and tobacco, right?
There certainly are stores that sell a wide variety of products, including some of the same products that might occur or might be sold in this specialty retail shop. So I acknowledge that.
That the Lowe's grocery store does sell tobacco and alcohol. That's what you're not acknowledging?
Yeah, so I acknowledge that they sell a wide variety of products, potentially including some of the products that would be sold in this specialty retail shop. So I don't dispute that. But where I drew the line in making my determination was, is it a specialty shop that specializes in just these products that have the potential to be more impactful on the community? Or is it a general grocery store, retail convenience store? And there's a very different set of impacts, I think, with those stores, right? So that was ultimately the judgment that I made.
And what is the land use impact that's different about tobacco being sold in a tobacco store versus the land use impact of tobacco being sold in a grocery store or drugstore like Walgreens?
Yeah, so I think, again, it is a very specific specialty store, right? It offers particular products that I think, in my judgment, in general, are potentially more impactful on the community, potentially more harmful on the community. And so I'm considering that. And so it's not so, my decision is not so much about whatever judgment about whether this is a good product or a bad product. It's more about, the community's leaders did not go through a deliberative process to make that judgment. And in my judgment, they should go through that process. And if they decide that that's a good, compatible use in this location of our community, that's great. If they decide that it's not, that's perfectly fine too. I'm happy to administer whatever outcome may come from that.
Do you have any reason to believe that the tobacco products sold at a tobacco store are more of a health risk than the tobacco products that are sold at Lowe's or Walgreens?
I suspect there are comparable health risks wherever it's sold.
Okay.
But again, I'm not an expert on these products. I actually learned a lot more about them in the 3 or 4 weeks in late April and May than I knew at the beginning of this process. So I don't claim to know all the impacts of these things. I made the judgment that it was different enough that it warranted more consideration. So,
going back to the section 14.8.22, please.
Okay.
If you look at the second sentence in that provision, it says, when a proposed use is not specifically listed in the table of permitted and special uses, the UDO administrator may determine the most similar use in relation to the use's impacts in the table of permitted and special uses and classify the proposed use in the same manner with respect to whether it's permitted or prohibited in a specific district. So if you felt that tobacco store is an unlisted use, the UDO gives you the power to treat it like the most similar use, right?
Correct.
Why not treat it like an alcoholic beverage store, which is permitted in B20?
I mean, I think that's a reasonable argument for someone to make, but as I explained to you, my argument was based on the deliberative legislative process by the leaders. You know, the fact that the community's leaders went through a process to specifically list all of these different types of specialty retail shops, that was the main thing weighing on my mind. And again, if you look at the language in this section, and if you keep reading beyond where you stopped, it makes it very clear that they can request a text amendment from the Planning Board and Board of Commissioners, or they can appeal whatever decision is made by the UDO administrator. So.
Okay, so the last sentence in that section we've been looking at, does it say, when a determination cannot be made, a zoning text amendment may be considered by the Planning Board and Board of Commissioners, or the applicant may appeal the UDO administrator's interpretation to the Board of Adjustment, right?
Correct.
Okay, so when it says when a determination cannot be made, what determination do you believe that is?
Yes, so ultimately I was not comfortable making a determination that it was similar, to use the language in there, and therefore defaulted to the guidance presented to me in the UDO that you just read. So.
Okay, so when it says when a determination cannot be made, is the determination the determination about how to treat the use under the UDO?
I'm not sure I'm following you.
Sure, I want to get your take on when it says when a determination cannot be made. What determination do you think that is?
So if you can't make a determination that the proposed use in a zoning permit application is similar enough or consistent or specifically listed because it uses the phrase specific, then that's when you move on to the next steps, the text amendment or the appeal. So again, I made the determination that it was not a permitted use. And I think there are good arguments. I think you make good arguments. I think I have equally good arguments and better arguments. And that's why we're here tonight. And this group of people will decide that. But, you know, again, ultimately, I could not get comfortable making a determination that it was a permitted use. I think it is different enough from general retail sales. And I looked at the fact that our leaders went through a deliberative process and identified all of these other specific type retail uses. And so I would like for them to make a judgment on this specific retail use and probably others in the future.
So with respect to this phrase of when a determination cannot be made, is it that a determination can't be made, or you just feel uncomfortable making that determination?
Yeah, so ultimately, I'm the individual who's tasked with making that determination. So I try to give it a lot of thoughtful consideration, try to educate myself. I try to think about it from different people's points of views and ultimately make the determination. And so ultimately, I hope I make good determinations. If the leaders determine that I don't, then perhaps they should find someone else to make those determinations. But ultimately, I'm the individual who's tasked with making that. And again, I told you the thought process that was used, and you may think that's great or you may disagree with that, and that's perfectly fine. That was the rationale used.
Okay, so with respect to when a determination cannot be made, have you made a determination or haven't you?
Yeah, so I ultimately made a determination that that use is not listed in our table of permitted and special uses. And so I communicated that to the original applicant. I communicated that to the owner of the property. I communicated that to another attorney at your firm. And so I'm comfortable making those determinations, and that's the determination that I made.
So this last sentence in the provision that starts with when a determination cannot be made, is that inapplicable here because you have made a determination?
I guess you can interpret that language however you want. I interpret that language as if I'm not able to make that determination, these are the other choices available to the applicant. And as far as I'm concerned, the process is working beautifully, exactly as it should. We're here tonight. And so I'm following the guidance in the UDO.
Did the town planning board meet yesterday?
They did.
And one of the items for discussion with the planning board was a potential UDO amendment to clarify the permitted uses in B20 and B30, right?
Correct.
Can I show you what I marked as Exhibit 3? I'll take a second to let those copies go around. Sir, do you have a copy of Exhibit 3 there?
I do.
All right. Is Exhibit 3 part of the planning board packet from yesterday?
Yes, sir.
And did it include a memo from you?
Yes, sir.
By the way, did the planning board take any action yesterday?
They took action. They recommended adoption of the draft ordinance amendment with some changes that they suggested. And so that will now move forward to the Board of Commissioners on August the 12th.
Okay. At this point, nothing's changed in the UDO as a result of yesterday's meeting, right?
That's correct. It potentially could change on August 12th. That's the soonest.
You would agree that for this case, the current UDO governs, not any forthcoming version that might be approved?
Absolutely.
Okay. Now, the proposed UDO amendment is a response to this very case we have tonight, right?
Yeah, absolutely.
And the point of the amendment is to clarify the UDO's treatment of certain uses, including tobacco and vape shops, right?
Correct. There are probably about, I don't know, 15 or 20 different uses that would be clarified.
And your memo includes a copy of a proposed ordinance, correct?
A draft that was the basis of the planning board's review and their discussion last night.
Yeah. And that draft, in fact, uses the word clarify in its title.
Correct. You know, this issue arose, and because there are several uses that are not specifically listed, I want to correct that for the future. But this case should be decided against the ordinance in place now at the time that the application was submitted.
Okay. Do you think that the UDO needs clarification?
I do, yes.
Okay. As it is it unclear on issues as to how to treat tobacco and vape shops?
Obviously, there's a question because we're here tonight.
Looking at first page of Exhibit 3, you told in this memo, the planning board, that the amendment would reduce uncertainty for property owners, business owners, residents, and town officials, correct?
Correct.
Do you think it's fair to say that people could look at the existing UDO and be uncertain about where a tobacco and vape shop could be placed?
Could you say that again, please?
Yeah. Do you think that if people look at the UDO as it is today, that a reader of the UDO could be uncertain about where you can have a tobacco and vape shop?
Yes, that's why I would like to clarify it.
Do you know, did the town advertise the ability for the public to make public comments relating to this hearing?
The hearing tonight?
Yes,
or
this hearing.
Yes, we did.
Did you receive written comments?
We did. They've been provided to your client as well as all the Board of Adjustment members. And I want to say we probably received about 15 or so written comments, give or take.
Okay. Were those sworn statements?
Those were simply written comments that were provided, so they weren't sworn statements.
Emails that came in, is that pretty much what they were?
Some of them were emails, some of them were handwritten comments, and I'll let Attorney Arnett determine the validity of those and advise the Board of Adjustment appropriately.
May I ask the board or its counsel to confirm that the supporting information packet from Mr. Rush, as well as any public comments that were forwarded to the board, that they're part of the record in this proceeding? I just want to know if I have to introduce that stuff as an exhibit. My understanding is that the administrative materials in the record would include items like this that are distributed to the board in advance of the hearing.
I think that's
You are
correct.
correct, yes.
Sir, do you know if town staff solicited comments to be sent in from vape shop opponents?
I do not believe they did.
I'd like to show you something if I'm
Sure.
Sir, let me ask. I've just
Sure.
handed you what I believe is something from the town's social media page.
Sure.
And want to know whether you've seen that.
You want me to provide this to them? And so I have not seen it, but the person who authored the post from the town of Cape Carteret, honestly, I think did an appropriate thing. Like we want to receive input from our citizens on every issue that our Board of Commissioners and our Planning Board is dealing with. And so the person, I guess, expressed a concern on social media, which obviously happens all the time. And she said, okay, well, why don't you just submit that to the town? I don't view that to be a solicitation of any kind, simply advising the person that they can participate in local government.
I'd ask the board to admit the exhibits 2 and 3 into evidence for the record.
Madam Clerk, you have copies of 2 and 3.
Sir, I believe that's all I have for now. Thank you for answering my questions.
Yes, Madam Chair, I'm Brett Selms, attorney for the town, and I'm not going to be long here. I just wanted to reiterate what Mr. Rush said during his testimony, in that he's given a playbook, right? And that playbook doesn't include everything in it all of the time. I think you guys could take judicial notice that vapes and the vape products are relatively new products, certainly not as long as alcohol has been around or other cigarette products and things of that nature. And this was a tough decision for him. He deliberated. He looked over the UDO and made, I think, an informed, reasonable decision. And tonight, what the town would ask you to do is to look at this UDO and determine whether his decision was reasonable, was appropriate, and followed that playbook. And if so, then uphold his decision. If you feel like he made a misjudgment, he did not characterize this correctly, then you can certainly overturn that decision. That's within your power. But we would advocate that this is a a matter that's important to the public. When you look at the uses that are listed within the UDO, there are certain listed uses that have been deliberated by the governing board. The governing board has made determinations as to where they should be, when they should be there. And that's what we think that this use should be, right? This use should be something that goes through that legislative process. And eventually the elected officials are going to have to make a determination of where they're allowed in the town. And that's what Mr. Rush did. I think it's totally appropriate for the town manager to look at the playbook, to play by the rules that he's been given from the town council. And in fact, I think it would have been inappropriate for Mr. Rush to take a step forward and step in the shoes of that town council. These folks don't elect him. These folks elect the town council. And so that's what he did. And we'd ask that you uphold his position. Certainly the applicant's going to be given an opportunity to present their side. I'd encourage you to listen to that. You have an independent attorney here tonight. I'm the town's attorney. I'm advocating for the town. Mr. Arnett's going to give you the law, what you should rely upon, what you should not rely upon. Anything I say tonight, just take it as that. This is not advice to you. This is advocacy on behalf of the town. But we do hope that you'll uphold Mr. Rush's determination. Thank you.
Thank you, Mr. Selms. Mr. Arnett, the next in line, I think, would be the applicant. Is that right? What?
I believe.
Yes, please. The applicant would like to call a witness. And just to clarify, I construe the town attorney's remarks as being more in the line of arguments rather than factual testimony. I certainly would like the opportunity to give arguments at an appropriate time after additional evidence is presented. But for now, I would like to call Jason Swain as a witness on behalf of the applicant. Mr. Swain, you've been sworn. If you can go up to the podium, this just so whoever you're going to stand, that's where you want to stand, just so that whoever's on there can hear. It certainly
It doesn't amplify the voice, but it allows people to hear. Does that make sense?
Yes.
Yeah, and I'll get out of your way.
If it's okay with the chair, I will take the town attorney's ledge here, and so I can be heard to everyone. Sir, can you state your name and address for the record?
Yes, my name is Jason Swain. I live in in Wilmington, North Carolina, at on Quail Run Road.
Okay. How are you employed?
I'm a commercial developer. Have been for over 20 years now.
But is there a company you're with?
Yes, Swain and Associates is our company.
All right. And what in general does that company do?
So we develop all kinds of income-producing properties all over North Carolina. We've been developing for over 40 years and have developed several hundred properties across the state.
Now, the applicant in this case is a company called SP103 LLC. Do you know what that is?
Yes, that's one of our many holding companies.
Okay, so just to explain what that means, does Swain and Associates own a lot of little companies?
We do. So to make it a little bit easier to understand, our company is Swain and Associates, but we hold all our properties in different entities. So different properties around the state are owned in different shell companies, and this one is SP103. It stands for Swain Property 103.
Okay, and that company is the owner of this site that we're talking about tonight, right?
Of the former Wells Fargo Bank. That's exactly right. That's the only property it owns.
All right. When did your company buy that site?
We bought it in April of this year, but we originally developed it and owned it prior to that and sold it. So we bought it back in April of this year.
Okay. Can you briefly summarize for the board the history your company has had with that property and the surrounding vicinity?
Sure. Probably roughly 20 years ago, we came to Cape Carteret and bought the shopping center. At the time, it was a Lowe's Food and several shops. After that, there was a Maxway out front. As many of you will remember, we tore the Maxway down and redeveloped the property and turned it into a Walgreens, and then brought the ABC store from its previous location to the location where it sits today. There was a gas station. It was a muffler shop, really, out in front of the shopping center where the Wells Fargo now sits, and we bought that piece of property as well. We cleaned it up. It was contaminated, and raised the building, and then we developed the Wells Fargo Bank. In addition, we added additional about 12,000 square feet of shops to the shopping center where the Sherwin-Williams paint store is. We also own the property to the rear of the shopping center that is Woodlands right now. We have also acquired the Marine Federal Bank, which was adjacent to the Wells Fargo and muffler shop, raised that and developed the Lowe's Fuel gas kiosk that is there today. And in addition to that, we bought the closed PNC Bank when they decided to leave the market, raised that property and developed the Starbucks as well. And sorry, I'll add to the record. We also expanded a couple of years ago the Lowe's Food. It was a very high performing store, and Lowe's wanted to expand it for there to be a nicer shopping experience for the people in town. And so we expanded that and added what you see today.
Super. I'm sure the board is intimately familiar with this site, but particularly for the record, I want to show you what's been marked as Exhibit 1.
Yes.
Is Exhibit 1 basically an aerial of this vicinity off of the county GIS?
Yes, sir. It does appear so.
Does it give a decent overview of where things are situated?
Indeed it does.
All right. Do you see a parcel that's marked in kind of a light blue?
Yes, in Carolina blue.
Okay. What's the Carolina blue parcel?
The Carolina blue parcel is the former Wells Fargo Bank, the parcel in question.
Okay. And hey, do you have a pen?
I do, yes, sir.
Can you, well, we know which one you're talking about. It's the only one in blue. But can you describe some of the surrounding properties on this map and where they're located?
Yeah, yes, sir. Directly adjacent to the parcel in blue on the right is the Lowe's Fuel kiosk now. That was the former bank that we raised and redeveloped. Adjacent to that, across Anita Fort Road, is the Lowe's Home Improvement Store, which we developed. I forgot to mention that earlier. We also developed the Lowe's Home Improvement Store. Behind the blue parcel is the shopping center, the Lowe's Food Store Shopping Center and related shops. To the left, if you're facing the blue parcel on Highway 24, to the left is the Walgreens, excuse me. And then directly across the street from the Walgreens is the Starbucks. Behind that is Hardee's, and then Ribeyes is behind that.
All right. Just so we have something for the record, if you would take your pen, do you see where the Lowe's grocery store is located on this map?
Yes, sir.
Can you write an L where the Lowe's grocery store is?
Yes, sir.
And by the way, does the Lowe's grocery store sell tobacco products?
Yes, sir, it does.
Do they sell alcohol?
Yes, sir, it does. They actually have a bar in the for serving alcohol on premises as well.
Right. You also talked about a Lowe's drive-through or fuel
Yes.
stop or something?
Yes, the Lowe's gas kiosk is out in front. It's directly to the right. If you're facing on 24, directly to the right of the Wells Fargo.
Okay. That kiosk, how about, can you write a K?
Yes, sir.
Where the Lowe's kiosk is?
Of course.
Do you know, do they sell tobacco products at that kiosk?
Yes, sir. I do believe they do.
Okay. Now, is there a Walgreens here?
There is to the left on this map of the subject site.
Can you write a W on the Walgreens?
Yes, sir.
And Do they sell tobacco products in Walgreens?
Yes, sir, they do.
Do they sell alcohol in Walgreens?
Yes, sir, they do.
Is there an ABC store in this complex?
There is, yes, sir. It's directly behind the Walgreens.
Can you write with your pen an A where the ABC store is located?
Yes, sir.
I'd ask to admit Exhibit 1, and if you could give the original to the clerk if she wants to let the board see where the witness has drawn the annotations. Now, sir, has the SP 103 LLC entered into a lease with a tenant for the parcel that we're talking about tonight?
Yes, sir, we have.
Does that tenant wish to operate a tobacco shop?
Yes, sir. They wish to open 60 days ago or so.
Let me show you, please. What is marked as Exhibit 4?
Yes, sir.
And is Exhibit 4 an excerpt from the lease that includes the provisions about how the tenant could use the property?
Yes, sir. This is our lease for the property across the street, a portion of it.
So looking at the second page in Exhibit 4, do you see a section 4A called Use and Operation?
Yes, sir.
Under the use provisions, does it say that the premises can be used solely to operate a retail store that sells tobacco and other products customarily sold in tobacco stores?
Yes, that's correct.
You know what, might this tenant also sell some general merchandise?
Perhaps, yes.
Does your lease expressly forbid sale of marijuana?
Yes.
Does it forbid illegal narcotic sales?
Yes, sir.
Does it forbid drug paraphernalia and other illegal activity?
Of course.
Does it forbid creating any noise, litter, or odor that would be a public nuisance?
Yes, without question.
Do you have personal knowledge about whether there's previously been a tobacco store in the shopping center?
Yes, there has.
When was that?
From 2014 to 2016, we had a tobacco shop called Smoker's Corner in the shopping center.
To your knowledge, would the proposed tobacco shop under your lease be substantially similar to what has already existed in the past?
Yes, they would sell the same products that were sold in the previous store, to the best of my knowledge.
Did the town take any action to prevent Smoker's Corner from doing business?
No, quite the contrary. It was my understanding that some of the town officials actually frequented the establishment.
To your knowledge, has the shopping center been in the same B20 zone going back to when Smoker's Corner opened?
To the best of my knowledge.
Have you personally had any discussions with town staff about this matter prior to your appeal?
Yes.
What were you told were the reasons for the staff's change of opinion on whether a tobacco or vape shop can be in a B20 zone?
Well, I had several conversations. In my first conversation when we bought the property, and before I bought the property, I had a conversation with Mr. Rush, and I told him that this is one of the uses that we were considering for the property. I knew that the town had interest in buying the property at the same time that we had interest in buying the property. We were successful in buying it, and I called Mr. Rush and I said, I'm getting ready to enter into a lease with a user that will be a tobacco shop. If the town has interest, in leasing my property for Town Hall because it was my understanding in conversations with Mr. Rush that the town had interest in moving Town Hall to that building before I owned it. I said I would be more than happy to entertain working out some kind of arrangement with the town to have them in the building. Mr. Rush advised that they were making other plans to buy and develop something somewhere else, and that they would not be interested, and that he closed in saying that he hoped that I would not lease to a tobacco shop. He did not ever tell me that the tobacco shop was not ever permitted in the district. He had previously told me at one point in time I had interest in developing a car wash on the site. And in conversation, Mr. Rush did tell me that a car wash was not permitted in the district. So ask me your question one other time, because
I'm sorry, and I think I was specifically asking about, well, are you familiar that town staff first said that a tobacco shop is permitted?
Oh, yes, I did.
Was there any explanation as to what led to the change of opinion?
No, not really. I know that the town did, Ms. Chambois in written correspondence did provide our user with confirmation that the use was permitted in the district, and she evidenced the UDO in making that determination in writing. And then it really caught me cold that the town was backtracking on that when my tenant went to pay the fee, I believe it was, to pick up the permit.
Can you briefly elaborate some on your experience in real estate and shopping center development?
Sure. We've developed all kinds of properties. Our family originally started developing Food Lions back before it was Food Lion. It was Food Town grocery stores back then. Developed some of the first Advance Auto Parts and Family Dollars in North Carolina.
And if I may stop you, my question was specifically directed at your experience.
Oh, my experience, sure. Sure. The day after I finished school, I started working in the company. I've done all aspects of I've worked in all aspects of our company, everything from property management to development. I'm in charge of buying real estate, identifying real estate, working with all of our various clients to identify locations for them. I then put together all the economics for them, do all the rezonings for them, put together the financing for them, hire the general contractors, do all the design work. We then hire someone to build it, and then we put permanent financing in place, and we own and manage the assets for the lifestyle of the asset.
How long have you been working in the industry?
Well, really, I started when I was old enough to hold a pencil and a piece of paper because my family would go on vacations and I would always be writing phone numbers down for my dad and then making maps of where the different properties were. But I've been actively involved in the day-to-day operations of the business for roughly 22 years now.
Do you have any licensures or credentials within the real estate or development industry?
Yes, I'm a licensed real estate broker in North and South Carolina. I'm a member of the International Council of Shopping Centers and attend their meetings. I'm on a number of different boards in the town where I live that are involved in business development and development interest.
Based on your professional experience, for a shopping center complex like the one we're talking about here, do you think a tobacco shop would be inconsistent with the other retail stores in the complex from a land use perspective?
No, I have them at a number of our other shopping centers around the state. This is the first place that I've had an issue.
As a business person, do you try to lease to tenants who you think are a good fit for your shopping center?
Well, I certainly do, and I certainly don't want to do anything that will harm the significance of my investment in the property or any additional properties that I own surrounding the property.
All right, thank you, sir. I'd ask to admit Exhibit 4 into evidence. Thank you.
Would you like for me to give it to the clerk?
Sure, that's fine.
Do you have a copy? Okay.
Do members of the board have any questions of the witness?
Yeah, I have some questions.
Mr. Swain, if you could come back to the podium, please.
how would you describe your relationship with the town, with your development? Sounds like you've got a big investment in Cape Carteret.
Indeed. We've always had a good relationship with the town.
Why do you think this particular instance is different?
I don't know. I think you'd have to ask the town. What we've tried to do is, before we bought the property, part of the process that I go through when I buy a piece of property is to try to find the highest and best use. And I look, part of that is looking at the development ordinance to see what is allowed. And so when we went through that process initially, before buying the property, made the determination that based on what the UDO said and the uses allowed in the district, that would be allowed to develop it or redevelop it for this use. I've always had a good relationship with the town and with Mr. Rush. I'll be honest, I don't think that his determination is correct. I did not get any word last night that the development ordinance was being changed, and I don't think that was right either. I think I've got a pretty sizable investment in our community, and I think the appropriate thing to do would have been to let us know. But you know, we develop in all kinds of small towns around North Carolina. I mean, I'm from Mount Airy, North Carolina, which is literally Mayberry. My father was born in Walkertown, North Carolina, which had a population of 500 people. So small town North Carolina is where we have done the majority of our work. And we work hard to try to improve the quality of life in the communities and to bring jobs and economic opportunity there as well.
I've heard you guys repeatedly go back and forth, and you've talked about this tobacco shop as though that's all they're selling. How does this improve over? How do you feel this is an improvement for the shopping center of the town?
Well, I do think it's. I mean, we have a vacant building there right now. The options that I have are fairly limited because the town has no public sewer. And so it's my opinion that having a tenant who's bringing, who is generating sales revenue for the community and jobs is a good thing. I think there's certainly, we can debate what are good and bad uses, but that's generally what I think.
Yeah, I don't want to give you the impression anyway that I don't want you to make money and
Sure.
do well in the town, because when you do well, the town does well.
Yes, sir. I agree.
But I just can't get over the continuous back and forth of a tobacco shop. It seems misleading.
Okay. Those are the products that they sell. You know, we exclude
There's
any.
a differentiation between a tobacco and a vape shop versus just a tobacco shop. And you say that you primarily are doing these in small towns and that you're not getting any pushback, but we constantly are seeing just what you guys brought up about the UDO and the town making adjustments as soon as last night. Moving forward, we're seeing this all over the state and all over the country. We're seeing these towns making rapid adjustments, and it seems as though the small towns are being probably targeted a little bit more than some of the cities. Is it easier to come into a small town? Is that what it is?
Well, I can't really comment on that.
Sorry.
It's okay. I can't really comment on what's easy and not, because everything is relative, and my line of work is just not easy at all, period, regardless of where I go. I mean, these tobacco shop, vape shops are generally staples at most shopping centers wherever I go anymore. It's, you know, it just is. And so I don't know. No, I wouldn't say that doing business in a small town is easier than doing business in a big community. I do business in Raleigh, and Raleigh is very difficult. The small communities on the outskirts of Raleigh are very difficult. And, you know, doing business in the town of Cape Carteret is not easy either. That doesn't mean that, you know, we're not proud to be parts of these communities.
Yeah. I see in the ordinances on permitted uses where it looks like the town specifically identified businesses that were permitted. And just from general reading and other case law, there is pretty much no way for a town to project every scenario several years out and what new businesses are going to come. And I can see where these issues would go before a town, and the town would make a decision based on what fits at that time. Referring to your lease, you have some pretty specific things that you don't allow in your lease, which I commend you for.
Yes, sir.
It does sound like a well-written lease. But it does leave, when you talk about the ordinance being vague, your lease has some vaguities to it too. When you say you don't allow the sale of marijuana, whether not legal or under applicable law, vape stores generally sell Delta 8, Delta 7, Delta 10 products. And through a chemical reaction, when those products are heated, it's converted to THC. And the THC content can vary, and also the THC content based on volume that they could smash together can have a psychotropic effect on an individual. How does your lease address that aspect of it?
Essentially, my lease addresses what's permitted under the law. So if these products that you're talking about are permitted by North Carolina law, then they could potentially be sold in the store. But I would say this, the line is clear that we don't allow anything that is not permitted under North Carolina law.
If North Carolina law changes, and currently there is legislation, I'm sure if you're a developer, you're aware of House Bill 563 that's looking to ban approximately 100 of these products across the state. That seems like that would have a pretty big impact on your tenant's ability to generate the income that you mentioned. It's a pretty sizable price for that building.
Oh, what I paid for it? Yeah, I did pay a lot for
I
it.
imagine you've got to lease it for a pretty good amount to get back that money. How does this come into play if these products are?
Well, if North Carolina outlaws any product that he's selling, obviously he wouldn't be allowed to sell it. How does that impact his business? I don't know the answer to that. If
Would
North,
it give him a legal way out of the lease if he's no longer able to sell a product that he was able to sell previously?
no, sir. He has an obligation under the lease for the period of the lease.
The other thing with the lease, it's, I mean, I love what you've included in it, so don't get me wrong, but there are some areas that are vague that allows loopholes.
Sure. Okay.
The reason we're here tonight. And you specifically defined that head shops not allowed, but you don't define what a head shop is. Do you have any idea what he's planning on selling in that building? I know we keep hearing tobacco. What is his plans? What has he told you he's planning on selling?
It's my understanding that he plans to sell tobacco products and he plans to sell vape products, and will probably sell some ancillary things as well. I would assume probably some potato chips, drinks. He usually has a drink cooler.
Edibles?
I don't think so. I don't really know. Are they outlawed? Marijuana is outlawed.
Does he own any other vape shops?
He does, yes.
He does.
Uh-huh.
Do you know what he sells in those shops?
Do
you know what he advertises that he sells in those shops?
Basically tobacco and vape products.
He advertises edibles. He advertises glass.
No, he's not allowed to sell glass.
He's advertising at his other shop.
Well, he's specifically restricted in my lease.
Okay. Who's going to oversee these products that are being sold in there? I mean, do you have somebody that's going to go by and say, hey, this isn't a product that's allowed to be sold?
Oh, sure. Yes. We police all of our shopping centers. We're here fairly regularly.
Would you be willing to, if at some point this were to move in either direction, to verify a signed copy of the lease that he's willing to abide by these terms?
Oh, he signed. Yes, he has signed saying that he will agree. That's the signed lease. So he's bound by law to agree to those terms. to uphold those terms.
Mr. Swain, this is not the entire lease, is that correct?
That's correct. It's only a few pages to show you the use provisions.
Anyone else have questions for Mr. Swain? Any of the attorneys?
I do have one very quick redirect question for him, if I may.
Mr. Fuss, go ahead.
Sir, do you know if there are any stores currently in the same B20 district that the subject property is located in that sell vapes?
Yes. As a matter of fact, the gas station next door sells the same products as well. And the gas station down at, I think it's Taylor Ocean Road, sells vape products as well and tobacco products. And I believe they're both in the B20 district.
Seeing none other. Thank you, Mr. Swain.
Yes, ma'am.
Thank you.
Mr. Arnett, what's up next for us in our procedures?
Next, other members of the public may present competent material and substantial evidence that's not repetitive as allowed by this board. And there's a 3-minute time limit for those individuals.
Madam Chair, may I, per discussions that I've had with council prior to the hearing, would like to ask to just make a standing objection with respect to any other comments that are offered. Our contention would be that evidence should not be taken by anybody who does not have standing in this case, meaning a party or somebody who would suffer some loss that is special and different from just a general member of the community, and would ask that the court determine whether any speaker has standing before allowing them to talk further, to the extent that, well, I would ask that and object to the extent that anyone who has not proven their standing is allowed to testify, and I'd like to generally, in the hope of avoiding having to say objection a lot, have a standing objection to just opinions that are not competent and material.
If I may.
Please.
General Statute 160D-406, and this is in response to what I believe I heard you say, that unless an individual has standing, they shouldn't speak. General Statute 160D-406, that's the quasi-judicial procedure statute that governs this hearing tonight. Subsection D is called presentation of evidence. It says, the applicant, the local government, and any person who would have standing to appeal the decision under 160D-1402C shall have the right to participate as a party at the evidentiary hearing. Other witnesses may present competent material and substantial evidence that is not repetitive as allowed by the board. So it is very clear that you do not necessarily have to have standing to speak at this hearing, as long as what they're offering, these other witnesses, they're offering competent, the terminology being competent material and substantial evidence.
Thank you. With permission of the board members, we have 3 folks who have asked to speak to us tonight, and if I may ask you individually, if you have evidence versus opinion, that would be Ms. Annette Myers. You have evidence versus opinion. All right. Michael King, do you have evidence versus opinion? You have both. Can you trim that to evidence? And Dot Marsky, do you have evidence or opinion? Thank you. Then we would ask that you stand down. And we'll have Annette Myers, if you would please come forward. If you would share with us, Ms. Myers, what your evidence is.
Yes. I started a petition. It has gone through most of Cape Carteret. We have 212 people who have signed the petition. I called Town Hall last week to ask if I needed to, when I needed to present this, and I was told that I needed to bring it tonight.
Okay.
So I would like, may
If
I
you
read the
could read,
petition?
read the narrative and then present it to the clerk, please.
Right. Petition requesting the Cape Carteret Board of Adjustment to uphold the original denial by town staff for the proposed rezoning of a vape and tobacco shop within the town limits. We, the undersigned residents of Cape Carteret, are petitioning to express our strong opposition to the vape and tobacco shop proposed for the former Wells Fargo Bank building at 301 W.B. McLean Drive. We understand that the town staff reviewed this proposed zoning request and deemed that the use was not permitted in the current B20 town zoning, and that the ruling is now being appealed through the Board of Adjustment. In addition, we ask the Board of Adjustment to consider the following concerns. Number one, vaping and tobacco pose significant health risks to all, but especially young people. Two, vape products are often marketed in ways that appeal to the younger demographics. Three, we believe that the introduction of a vape and tobacco shop would detract from the family-oriented environment of Cape Carteret. Number four, Cape Carteret has many positive and quality businesses that add to the appeal of our community. A vape and tobacco shop is not seen in the same positive light as other businesses that are established here. Number five, the presence of a vape and tobacco shop could have a negative impact on the property value of our neighborhood. Potential home buyers may be deterred by the proximity of such a business, causing a negative consequence for current residents. And number six, many products that would be offered are already found in businesses near Cape Carteret.
Thank you, Ms. Myers.
And
Any
I
questions
do-
for this witness? If you could present that, please, to the clerk.
Thank you very much.
Thank you.
Madam Chair, I do not have questions for the witness, but just for the record, let me object to the offering of a petition to the board as evidence, and object to all of that testimony as not being material, and specifically any evidence regarding the impact on property values as being incompetent, without someone qualified to testify on such an issue.
Duly noted.
Madam Chair, I would
Yes, sir.
agree with that opinion.
Thank you. Mike King. Facts, Mr. King? Evidence, Mr. King?
I'm sorry?
Evidence that you're presenting to us?
Yes.
3 minutes. Clerk, are we going?
Can you hear me?
We can.
Madam Chair and board members, I speak before you this evening to consider a few thoughts on the matter that is before you tonight. First, the table of permitted use has always been very specific, identifying clearly what the particular use is, and rarely, if ever, has a retail sales category been used to permit a specific use. Tobacco and vaping are very specific, age-restricted, controlled substance that should receive a planning board review before presentation to the Board of Commissioners. Second, the original permit submitted by the applicant requested approval of a convenience store. Was this really their intent, or was this an attempt to deceive? With the convenience store literally across the street and a second one a half a mile down the road, it doesn't make any sense and could only be viewed as it was an attempt to deceive. Third, marijuana is still illegal in North Carolina. However, THC, the compound that creates the high, is legal and is present in vaping devices. Tobacco is a highly addictive with highly addictive nicotine has long been deemed hazardous to our health. Why would we approve a tobacco and vaping shop in the center of our town, knowing full well of its addictive qualities and the likely long-term health hazard it will bring to our residents? Vaping is proliferating among school-aged children and teenagers. Vaping THC oil can harm lungs and has been associated with serious lung injuries and death. It also carries an increased risk for cognitive impairment, dependency, and psychiatric symptoms. Both the CDC and the FDA recommend avoiding all e-cigarettes and vaping products, especially those containing THC. Thank you.
Thank you, Mr. King. If you would provide the clerk with your remarks, please.
And just for the record, I would object to that testimony as not being
Madam Clerk, did you get the applicant's attorney's objection? Thank you. All right, moving forward, where are we, Mr. Arnett?
Are there any other citizens that wish to provide evidence?
None that signed up. There are none.
Madam Chair, now the matter is now with the Board of Adjustment to make a decision and deliberate.
All right.
I'm sorry, Chair. As noted earlier, I would like to make some closing arguments essentially. Now is the right time. I'd be glad to do so.
Madam Chair, I think that would be appropriate.
That's fine. Sure.
Okay. Thank you so much. Thank you for your time and attention this evening. In making your decision, I'd like to first review what you should consider and then what we respectfully contend is the only legal result in this particular instance. First, as you know from your counsel's guidance, you should only consider competent and material evidence, not comments or opinions from general members of the public about whether they like the idea of a tobacco shop or not. Everyone is certainly entitled to their opinion, but this is not about whether a tobacco shop would be popular or whether any member of this board would personally prefer to have a tobacco shop or not. Secondly, this is not about future cases. The town might change its UDO tomorrow, and if so, tomorrow's cases can be governed by new laws. But this case has to be decided on the UDO that we have. What this case is about is whether the town's existing UDO allows tobacco shops or tobacco and vape shops in a B20 zone. Or put in a different way, whether the UDO can legally be found to prohibit them. This is a tough decision to make. It requires getting into the weeds of what the ordinance says. But we submit that you should reverse staff's decision for several reasons. Number one, a plain reading of the UDO shows that this use is allowed. The property we're talking about is B20. Sales retail is permitted by right in B20. This is obviously a form of retail sales. I think the town manager acknowledged that this is a form of retail sales we're talking about. So unless there's something in the UDO that says tobacco shops or tobacco and vape shops are treated differently from other retail sales, that's the end of the analysis. If it's retail sales and you have a UDO that says retail sales is allowed as of right in this zone, and there isn't something else that says, but tobacco shops are treated different from other retail sales, you got to treat it as retail sales. The town can't make up new rules that aren't there. I'm not trying to accuse anyone with the town of doing something insidious. I'm sure everyone is trying to make sure that the best things happen for the town of Cape Carteret. But at the same time, the decision here needs to be made in the context of what does your UDO say and what are the rules about interpreting your UDO. Now, interestingly, so the town council has created the UDO. They have created certain special categories for certain specialty types of retail sales, like alcoholic beverage store. I guess that's retail sales, the ABC store, but there's something about alcoholic beverage sales that made the council say, we got to treat that different from just normal retail sales. But importantly, they didn't do that to create a special separate treatment for tobacco and vape shops. And if they didn't make a rule that says that's different, that particular use is different than other retail sales, it's just retail sales. And since the UDO says sales retail is allowed by right here, I would contend that it must be allowed by right. Now, there's this provision in the UDO relating to unlisted uses, but it does not provide a basis to deny a use that's otherwise allowed under the UDO. That provision, I would submit, is aimed at situations where there's some proposed use that's some weird thing that no one contemplated and that doesn't fall under any use listed in the UDO. My ridiculous example earlier, the time portal or whatever, that didn't exist, so nobody ever thought about writing something in. Here we don't have an unlisted use. We can't say, tobacco or vape shop couldn't fall under the existing categories, so we got to figure out, how to handle something that's not addressed at all. It is an existing use. It's retail sales, retail. The town wrote sales retail as a use. That's this, unless something in the UDO says, but you can't treat tobacco shops or vape shops different from other retail sales. Moreover, even if a tobacco or vape shop was treated like the most similar special retail use, as there's some discussion of in that unlisted use provision, it really should be probably treated like an ABC store. I think the town manager more or less agreed, yeah, if you had to pick something that's comparable, my concern is maybe this is something that's not really healthy and it's an age-restricted product or kids can't buy it. It's kind of like alcohol. But alcoholic beverage sales, the closest thing you can come to, is also allowed in this very zone. So if you treated it like that, you'd come out with the same result. Notably, also there are a number of places where you can buy tobacco and even vapes within this B20 zone already. The subject property is literally surrounded with other places that sell alcohol and tobacco products, and even with respect to the Circle K that's a stone's throw from here, vape products. Now, before I close, I just want to also underscore how basic precepts of North Carolina zoning law require a reversal of the UDO administrator's decision in this case. So this board needs to make its decision within the context of North Carolina zoning law. I mean, if it doesn't, some court or whatever will reverse you. So that's the goal here, is to do it according to the law. And I'll have a handout to pass out in a moment. But one sort of basic precept of North Carolina zoning law is you can't prohibit something by failing to say that it's specifically allowed. Basically, you can't say, well, since we didn't say vape shop is allowed, it's prohibited. I would like to, if I may, hand out just a one-pager with some North Carolina case law excerpts. And this just has some excerpts of key provisions of North Carolina zoning law. And if I may, for the council that are present here, I brought copies of the whole cases that I've cited, so we can make sure that I'm accurately representing what the law says. Okay, so this idea that you can't prohibit something by failing to say that it's specifically allowed is something that our North Carolina appellate courts have emphasized. For example, going back to the 60s, the North Carolina Supreme Court said zoning regulations are in derogation of common law rights. They're something that's not historically something you saw in the law. And they cannot be construed to include or exclude by implication that which is not clearly their express terms. It's been held that well-founded doubts as to the meaning of obscure provisions of a zoning ordinance should be resolved in favor of the free use of property. Likewise, a case from several years ago that's a very important case called the Byrd case. The North Carolina Supreme Court said that a dissenting judge in the Court of Appeals was right about a zoning question when he said it would be absurd, but more importantly unlawful, to support the notion that an otherwise legal use of private property is automatically disallowed simply because the government failed to identify it by name in a zoning ordinance. So here we have, retail sales are allowed. If the UDO and the drafters of our UDO here didn't put something in saying, but tobacco and vape shops are different and they're treated different, you can't just intuit that. Another basic precept of North Carolina zoning law is where there's a lack of clarity, you have to find in favor of the property owner's rights. So, for example, in the Morris Communications case, 2011 case from the North Carolina Supreme Court, they said, this Supreme Court has long held that governmental restrictions on the use of land are construed strictly in favor of the free use of real property. When interpreting zoning regulations, which are in derogation of common law rights, and faced with more than one reasonable interpretation of the regulation, we should choose the reasonable interpretation that favors the free use of property. So also in the Visible Properties versus Village of Clemens case from a couple of years ago, this was a case in which I actually represented the Village of Clemens trying to stop somebody from building something that some people didn't like. The court found that the UDO in Clemens was unclear. And this is what they said the consequence was. Where there's ambiguity, that is correct. This is a,
Excuse me, please. We'll be civil. Go ahead, sir.
thank you. According to our Court of Appeals, when there is ambiguity in a zoning regulation, there is a special rule of construction requiring the ambiguous language to be construed in favor of the free use of real property. The drafters of zoning ordinances, the Court of Appeals said, that restrict property rights have a responsibility to provide clear rules on which property owners can rely. This is so because zoning regulations are not intended to be a system of murky, ambiguous rules where the permitted uses of property ultimately depend on the interpretive discretion of government bureaucrats. So here, do we have a case where there could be two reasonable interpretations? Almost admittedly, I think Mr. Rush was quite candid in saying, hey, I think you got a point, but there's a counterpoint, and I'd prefer that the town council or whatever make a policy decision. Under the law, if you have two reasonable ways to interpret what the UDO means, it tilts towards allowing the property owner the free use of their property. That's just the philosophy under North Carolina law. You can like it or not like it, but it's the law. That if the government isn't clear and specific about what you can't do, then we're not going to take away private property owners' rights to do what they wish with their property. Also, just quickly, a couple other basic precepts. Undefined terms are given ordinary meaning. That's a proposition that's also shown in the Morris Communications case. So here in the UDO, there is a use that's called sales, retail. There's nowhere in the UDO where it says sales, retail means X. So what you need to do is treat it like you would normally think it means. So here, are we talking about sales? Yes, it's a shop. Are we talking about retail? Yes, it's selling stuff to the public. It's not like a wholesaler or something. It's retail sales. Finally, I'd also note, I just made a reference to the Through the Looking Glass case that says where the fact situations are exactly the same in two cases, the decision should, of course, be the same. It's notable that Mr. Swain is intimately familiar with the history of this property and has testified several years ago there was a tobacco shop that's basically the same type of shop that we're proposing here now, and it was allowed then. Saying, oh, well, we allowed that then, but we're not going to allow it now, is not something that the board should do. In closing, I do appreciate your time. I know this is a difficult issue. I ask that you give it proper attention under the law, and thank you for your decision.
Thank you. I have one further question for Mr. Swain. Mr. Swain, if you don't mind, and I meant to ask this earlier, I apologize. I'll let you sit down before I ask. Did you provide a copy of the lease and the permitted uses that you would allow your tenant to have in that property? Did you provide that to our town staff when they were making a determination about the application?
No, ma'am, it was not requested.
Thank you.
Madam Chair, I'll just reiterate my comments earlier. I don't want to belabor the point. And I'll also just respond to one thing in particular that was said about treating the same businesses the same as before. I agree wholeheartedly with that, but This UDO, as you'll see, was adopted much after the 2014 timeframe that was mentioned before. So we're not really comparing apples to apples there. So I'm not aware of a case that has come before this board since this UDO was adopted that addresses this issue. So this would be a case of what I would consider first impression with regard to this UDO. So that's all I have.
Thank you. Thank you, audience, for your patience. We have a decision to make. I will turn to my board members. Do you all want to proceed with this tonight? Do you want to recess and reconvene after you've had an opportunity to study the evidence? I'll take a motion one way or the other.
I make a motion that we reconvene based on the simple facts that this lease, I trust what you're saying, this is what they signed, but I have 2 pages of it. And also the simple fact that the zoning permit mentions convenience store. I've heard convenience store, tobacco and vape. I just need to understand what is it actually going to be.
And so I hear you saying you need more time. There's been a motion that we recess and reconvene. Is there a second? All those in favor, please notify by raising your hand.
If we could have clarification with the motion, we would need, the decision needs to be made per your ordinance within 30 days of today.
We will, I have a suggestion that we reconvene on August the 7th. Wednesday, August the 7th at 6:00 p.m., please. That gives us 2 weeks. Are there any objections to that from the board? Seeing none, that's what we will do. Thank you, ladies and gentlemen.
And just for clarification, during this time, this is for the members of the Board of Adjustment to consider the evidence that's been presented, not to discuss the matter or deliberate or to receive additional evidence.
Right, no additional evidence. Thank you.
And on the clarification, we are striking the testimony about the previous tobacco shop. Is that correct, since it's not relevant to this UDO and this is a first-time issue?
I'm sorry, I didn't hear that, John.
When you had mentioned that the current UDO that's been in place did not, that the tobacco shop that was in the shopping center was prior to this UDO?
Yes.
Is that correct?
Yeah, that was just an argument. I mean, I think that the UDO is something
Well, it was
that,
used repeatedly as evidence and justification.
right.
So I would assume that it's not evidence and justification if it's not relevant to the case.
I would not recommend striking any of that testimony.
All right, then we are in recess until 6 p.m. on August, what did I say? 7th. Good night, ladies and gentlemen. Thank you for being here.